2, 1, and we're live. Hello, everyone. Welcome to About My Book Business. I'm really excited to see you all today and happy to be joined by my co-host, Deborah C. Mortimer. Say
Yes.
hello to the people, Deb.
Hello. So happy to, sorry I missed you guys just last week. So happy to be here today.
Yes. And you were missed. So I am so excited because it's just the two of us today, and we're going to lean in big time on Deborah's expertise, one of her areas of expertise, which is the legal aspects of publishing. But before we do that, let's do a catch up. What's going on this week? What's new and exciting with
Oh,
you?
wow. What's going on this week? uh, well, I posted, like we're both in the NASDAQ milestone cohort for small business owners. We're so excited about that. I think if you go on both of our LinkedIn's, you can find a link if you would like to apply if you're a small business owner, if you'd like to apply as well. They're running it for, I think, all year, right?
Yeah, they have ongoing cohorts. Yes.
Yeah, so definitely that's exciting. I am putting the finishing touches on a new children's book. So I'm excited about that. And getting ready for the vending season, especially when it starts with Juneteenth next month. And that's about it.
Wait, but you didn't mention that it's Children's Books Week.
Oh, that's right. It's Children's Book Week and Teacher Appreciation Day.
It's
So
Teacher
that's really
Appreciation Day.
so that's great. Um,
Shout out to the teachers out
Shout out
there.
to the teachers, and I should have some stuff planned for it, but I don't.
All right.
Which is kind of bad. I don't. But I plan on posting a lot this week about it. So
Yeah, that's great. Yes, I love it. And for me, yes, started the NASDAQ Entrepreneur Milestone Circle this week, and that is very exciting. It's going to be so awesome.
I'm looking forward.
And hitting a major milestone, I realized that the timing is such that we'll be graduating just at the time that I'll be hitting my 2-year anniversary going full time in the business this year. So I'm excited about just kind of moving forward that. So I'm really psyched for that.
Oh,
yeah.
That's great.
It's very cool. And then, I have been working with my clients, getting a lot of media exposure. I have another client's book launch coming up, which is very exciting. And then I'm just really leaning in on this product launch that I'll be working on, which is my greeting cards and stationery business. And we're going to hear more about that very soon because almost 300 people completed the survey. And there is someone who has been selected as the recipient of the $25 gift card, which is what I offered for people to enter for a drawing if they completed the survey. So I'll be sharing the survey results soon, as well as the person who is the recipient of the $25 gift card. So thanks everybody for participating, and more to come on that, including the announcing of the name, the branding, all that fun stuff. And you'll be seeing a lot more about that project in the coming weeks. So yes. And of course, because it's a new brand, this leads right into the conversation about about the legal aspects of publishing,
which there are so many.
There are so many. And that's why we wanted to make sure we cover this, because isn't that one of the big challenges, or one of the big things that people come to you for, Deborah, is the whole issues with legal. So what's your top question that people ask you about?
Well, it's usually coming from self-published authors, of course, right? And I wouldn't say that there's a question that they ask me because they don't know what they don't know.
Okay. I get that.
They don't know what they don't know. It's when they're talking to me and things will come up, and then I say, well, this, and you should do this, and you should do that. But I think they probably ask me, how do they protect their idea? So let's say they have a manuscript that hasn't even been written yet, and they just have like an idea for a story, or an idea for like a book series, or a animated series, or something like that. They're like, oh, can I trademark that? Oh, can I copyright that? And I'm like, you can't protect an idea with trademark or copyright? Because ideas are floating everywhere, right?
Right.
And
And
you
that's the
can't
thing.
protect
People
it.
always say they don't even want to tell you because they're like, oh, somebody's going to steal my idea.
And right to protect that. But what I tell them is the number one way that you can protect an idea that hasn't even come to fruition yet is through an NDA.
Okay, well, tell more about that. What
Okay,
do you
so
mean?
NDA is a non-disclosure agreement, because if you have someone who signs an NDA, then that's just proof that they had access to your idea and agreed not to share it, and they breached a contract. So now you can get them on breach of contract. Give you an example of when I used an NDA. So I had a book that I wanted to get illustrated, and the illustrator wanted to see the book. And this is actually a manuscript that was actually completed, but they wanted to see it before they decided whether they wanted to actually work on it or not. And I was kind of like, trepidatious about it, because I'm like, if they see the book, they can, use it. What's to stop them? But I had them sign an NDA before I was willing to disclose my book to them. So that's a good way to protect your work if you just have an idea, or if it's just like at the really, really beginning stages, and you don't want anyone to steal it. It's not going to prevent them from stealing it, but it gives you at least a remedy if they do.
If they do, yeah.
Yeah.
So, and that's one of those things where I think about, like, even entering into a conversation, you just wonder how complicated things have to be for you to have a conversation with somebody. But when you're talking about your business and you're talking about your
Mhm,
ideas that you're intending to profit from,
mhm,
then
mhm,
yeah, having
mhm.
that document seems like a logical thing
Yeah,
to do.
yeah.
And if you have a template for it, which I know you will help people with,
Mhm,
then that's something that they can
mhm.
use over and over again, right? It's not like it's something that you have to make a new one every time. You just you
Right,
can update it. So
right.
that's really good.
But I wanted to
So
be clear
that's
on something, though. I wanted to be clear just on something, that the NDA is more applicable to an idea. Just because
okay.
you have that idea. One thing that I missed out saying in my little situation was I had a manuscript. So yeah, I had them sign an NDA, but I also had it copyrighted. So because if you have that manuscript, you want to copyright, and a lot of people don't know what copyright is. They don't really
Exactly.
understand. They think that you copyright just the idea, but you don't. So really quick
So what does that mean? Yeah.
yeah, a really quick explanation of what a copyright is. Copyright is when you take an original work and you affix it to some sort of a tangible medium. So like if you have, a book, a writing, a story, a recording of some kind, audio or visual recording, that's an idea that's actually put in a tangible form. And that is the thing that you copyright. So another example is I have another manuscript that I don't plan on publishing. I don't really think I want to publish it myself. I think I want to have someone else publish it. So I've been sending it out in queries, and I copyrighted it before. It's all registered before sending it out. So I know that it's protected. There's a misconception. Yes, a work is copyrighted the moment you do it. The moment I have an idea and I put it on paper, it's automatically copyrighted, automatically. However, in order to sue for infringement, you have to have like real hardcore proof that you copyrighted it, that's yours.
That
And the
is
best way to
yours.
do that is to register it with copyright office, copyright.gov. You have to file it.
So okay, so that makes me think. I know people who are like they do the poor man's
And that
copywriting. And is that like a real thing? Is that legit?
no,
Because
it's
I
not.
know
That
people,
point,
yeah,
no,
they like put it in an envelope and mail it to themselves, and they
no,
think that they're protected.
no. There is no evidence that no, that's not. That's poor man, wrong man.
I want you to clear that up
Poor
because I
man,
know I was
wrong
like,
man. No,
"What are
no,
you
no.
talking about?"
It doesn't work. That doesn't. People say that you put it in an envelope and mail it to yourself. No, no. Go. It's $65. Go to the
$65?
for the
People
application.
are not paying $65
Sixty-five
instead? Oh
dollars.
my
Go
gosh!
to
Wow.
go to copyright.gov and go just upload it, and within for my manuscript that I sent out, it was done within, I think I got it in 2 months. I got my certificate in 2 months.
Yeah.
I just filed it at the end of February, and I got it like last week.
Yeah. Well,
But
some people are in such a big hurry to get these things though, but there's stuff that they can do in the meantime, right? Like you don't have to wait until like
well,
is there a reason that they feel like they have to there's this urgency about copywriting?
Well, if you're not seeking the traditional path and you're doing, just self-publish, but you want to say get beta readers, because I've done this before. You have beta readers. There's measures that you can do because I'm fanatical about protecting my work. So I'm
That's
like,
your business.
right, I'm thinking about all the things that I can do to protect it. And I noticed that I had a friend of mine who was a member of the Academy of
Mhm.
the Arts and would get movies to review. And I found it interesting that the movies had a watermark across it with her name on it. And I was like, why they do that? They said because if it gets out into the public, they know who to trace it back to. So when
Ah,
I use beta readers, what I do is I just use Adobe. I put a watermark. I put like all kinds of protection on it. So I have it password protected, and then I have it password protected where you can't download it and you can't print it. And then I have a watermark across it with the person's name whom I'm sending it to.
so
So
why would their name and not yours?
well, because if it's their name and it shows up somewhere,
Then you
like
know
like if I
who
put your
whose
name, if I
beer
put
it is.
Tresa Chambers across it, and
Mhm.
then I find it on the internet somewhere,
Yeah.
and it's watermarked with Tresa Chambers, well, I know you the one who leaked it.
Ah, okay. I love that idea. I love that
I love
idea.
that. So, and then with Adobe, it's like you can share it. I just share it with and then I give them a certain amount of time so they don't have it forever. So I share it for let's say 24 hours and give them an opportunity to read it and review it and then I just remove the link and then they have no more access to it. So the password protection, they can't download it, they can't print it. It's got a watermark and then I take it away after they've reviewed it. And on
Oh,
top, and above, I'm crazy, I know, because I'm a lawyer. And above the work, I have that it's mine. I have the copyright language, and I have that it cannot be that by reading this or accepting this,
right.
you have that you've accepted the responsibilities or whatever, and that you understand that you can't copy all the
Yeah,
things.
share it,
Yeah,
duplicate it,
all the things. So
anything.
you understand.
Nothing.
Right,
Uh-huh.
right. So,
I
I'm a
love it.
litigator, so everything I do, I'm thinking of what is the evidence that I could possibly give for something later on. And I hope that that's all I can use. I mean, are there ways around it? There probably are ways around it, but I have my evidence that I gave it to you, that I did all the things that I was supposed to do. So that's, yeah.
Right. That's awesome. Well, I mean, and that makes sense. Yeah, something that that you value that much and you put all the time and effort into creating. Yeah, somebody shouldn't just be able to take it. And we're
Yeah.
going to talk a little bit about AI related to that a little bit later
Oh,
because
yeah.
that's
Oh,
definitely
yeah.
a big topic.
Oh, yeah.
So, okay, so now we've got the NDA, we have our copyright protection, and then we're moving farther along into the publishing process. And of course, we're talking contracts
Mhm.
because even if you're self-publishing, you're working with a hybrid publisher possibly, or if you are a children's book author or anyone who's sharing their story and you're contracting, you're having an illustrator involved, then there are contracts that are coming into the situation. So is that right? Or when do you start looking at contracts?
When you first start working with, when you decide that you're actually going to start working with this illustrator or this editor. But I just wanted to just touch on a question that I do get asked about copyright because some people
About
don't know.
copyright?
Yeah, just really quickly, they don't know like what does copyright allow them to do and like how long is it good for? Some people think it's good for like forever. It's not. So copyright is generally, if it's a work that's now after 1978, which would be all the anything that someone's putting out now, it's good for the life of the author plus 70 years. And if
Oh,
it's
okay.
like and if it's like a collaborative work, then it's for the life of the last living author plus 70 years.
Wow.
So it's a pretty long time. And once your work enters into the public domain, then anybody can use it. Like if you think about books that are like reproductions of like I don't know,
Shakespeare.
Charles Dickens or something like that.
Yeah.
Those are like public in the public domain so that
Public domain.
they can use that. And copyright really gives you the authority to reproduce, distribute, publicly display your work, and distribute. Oh, and to make derivatives of your work.
Okay.
That's what it gives you the right to.
Okay, so talk about derivatives real quick because a lot of people don't understand what that means. So just kind of
Well,
like
okay, so if you have a work and it's not largely changed, if it's just maybe a couple of lines that are different, or if you have a picture but maybe you put it was black and white but now you're doing it in color, or it's something is just slightly different, then
Okay.
that would be a derivative work, and
Okay.
you're still protected because it's overall it's yours. It's your
Okay.
idea. Yeah.
So like an updated edition of a book that you originally
Yes.
published several years ago,
Yes.
you don't have to copyright it again.
No, unless
Okay.
there's a material change. It would have to be like a material change. I mean, I would still do it anyway. I would just, because you can pick when you're registering a copyright, you can pick whether it's what edition it is. So
Okay.
I would do it as like a second. I would still do it
Second
anyway
edition.
because I'm
Yeah.
paranoid. I would do it. But going back to the contracts,
Yeah.
I
Yeah.
would
So
say that,
contracts. Yeah.
that if you're working with an editor, like you're an editor. I've worked as an editor. When you're ready to start working with someone, I always say, okay, let's have an agreement, because what does this do? It memorializes whatever it is that you agreed that you're going to do. What the work is that they're going to do, what the fee is, what the time frame is, what you're expecting, what the deliverables are. Everything is memorialized in that agreement so that at the end of the day, if there's some sort of a disagreement as to what you received or what they were supposed to do, go back to the agreement. Go back to the agreement, because if you're going to, if there's something that you feel like you were owed a refund or you want your money back or what have you, a verbal agreement, it's not going to be enforceable. You're going to have a written agreement.
Right. And with editing, especially, because a lot of people don't understand that, what you want to make sure you're clear on what the terms are, what type of editing even, right? Because we types of editing. So setting that realistic expectation and understanding what you're actually paying for if you are contracting with somebody, and understanding what the deliverables actually are is really, really important with the contract. So yeah, that's really important. So yeah, go ahead.
I was going to say, but also going back to the editor, you want to make sure you also have like NDA. You want to have that confidentiality in agreement, specifically with an editor. You want to have the confidentiality because you want to make sure that they're not sharing your work with anyone while they're working, and that they're taking the measures to keep your work confidential while they're working on your work.
So would you do a separate contract for an NDA, or would you put that into the main contract, the NDA component?
No, that would just be a clause.
Element of the clause.
Yeah, that would just be a confidentiality clause.
Okay. Yeah. That makes sense. Yes.
Yeah.
So, and now what about the illustrator? So working with an illustrator, what is that? What do you have to consider there?
So you definitely want to have an agreement with an illustrator for a number of reasons. And I know some people who did not have agreements with their illustrator. Give you an example. So because you want to have two, well, let me back it up. I'm getting ahead of myself. So you want to have two things in it. You want to have the confidentiality, and you also want to have exclusivity, because you want to make sure your illustrator is not sharing your work, because you may share your manuscript. Sometimes I don't share my manuscript. Sometimes I write illustration notes. And I do that mostly because for illustrators that are out of the country, because I can't really reach them, right? So I'm kind of leery about sharing my manuscript. But you definitely want to have confidentiality, but you want to have exclusivity, because you want to make sure that whatever they're working on for you, they're not working on with someone else or sharing the same images with someone else. I usually have a clause in there that says that all of the images and the characters and everything that they're working on for me are for me, and they won't replicate it for anyone else, because you don't want that, right? But then you also want to make sure that you have, if you want to retain the copyright of the images, you want to make sure that's in the agreement, because I know people who think that they own the images and they don't. All they had was a license to use the images. So you want to make sure
So
that.
talk about what the problems that can come up with that. Give an example of
Okay,
what.
give an example. So here's a major reason why you want to have an agreement. So as you know, When You Give a Girl a Puppy was read on Ryan Reynolds' show, right? And the first thing that they asked me was, did I have ownership? Was ownership of the images of the illustrations, were they transferred to me? Do I have the rights to the images? And I said yes. Well, the first thing that they wanted to see my agreement as proof.
Why?
Well,
Why?
because if I didn't show them an agreement that was, you know, prime proof that I do have copyright in the images, and they were to use the images in their show, whoever the illustrator is who actually owns the images could go after them. So
Yeah.
that's a liability issue. They want to protect themselves. So you definitely want to make sure that that's in your agreement. Now, you have certain illustrators that want to retain their copyright, that don't want it, that they just they would rather have it and then receive royalties for whatever, or they want to be a part of the conversation if your book happens to get picked up or something or whatever. And then you have some who are more than willing to just hand over assign the copyright. So you want to make sure that you know what you're getting, because you have the assignment of the copyright, which everything is completely transferred over to you. Then you have an exclusive license, and you have the non-exclusive license, which you don't really need an agreement for. Exclusive license means that whatever they're doing, that's the exclusivity, right? That they're licensing the images, but they're licensing it to you and you only.
Exclusively.
Right, exclusively to you and you only. Whereas a non-exclusive license means that they can give it to anyone. Case in point, member of a sorority, Zeta Phi Beta Sorority Incorporated, and we have many licensed vendors. It's a non-exclusive license because that means that anybody, if you file the application and you're approved, you're a licensed vendor and can sell licensed products. That says licensed Zeta products. If it was an exclusive license, that means that it would be only one vendor can sell those products.
Yes.
So you want to have an if you don't have an assignment which is a transfer of the copyright, then you want to make sure it's an exclusive license just for you. Just for you.
Just for you. I mean, and so having worked in product licensing, working on Goosebumps, right? So there's that exclusivity also about product development. So you can have an exclusive license for a particular type of product
Mm-hmm.
that you're licensing your character to.
Mm-hmm. Mm-hmm.
And then, but that's also an aspect of the licensing and that exclusivity clause, because you don't want just anybody being able to put your character on a t-shirt, because you have standards
Mm-hmm.
about what the quality of the product is going to be, and you get to review and approve that. And once you start selling stuff and it's non-exclusive, then you're diluting your brand, and people can sell stuff at the lowest price possible.
Mm-hmm.
I always think about, in New York, Chinatown, all those fake designer bags.
Canal Street, right? That's all kinds.
Yes.
That's all kinds of
Yes.
trademark infringement. All kinds.
Exactly.
So you're
And so
absolutely right.
you have to, and that's the other part, right? Once you own the trademark, and you have to protect it. I know we're going to go into that
And we're going to go into
next.
that.
Yeah, but that's with the exclusivity, it's really important to have that.
Now and if anyone wants to read it, they can go on to my blog on deborahcmortimer.com, because I have one blog post that deals with this. But if you want to know if your agreement is just a license and not an assignment, it would have a reversion clause. Because it has to be some act or some event that happens that reverts the license back to the owner, where you no longer have a license to use it. So if it has that in there, then chances are you just have a license. But what you can do, and some people have asked me this because they work with illustrators who don't want to assign or transfer the copyright. But what can they do? Well, you can add an option clause. And I would always say, let me just give a disclaimer here, that this is all general information, that you should definitely consult an attorney first for the exact language on how to put this in your contract, especially an attorney in your local area, on how to add the proper language to it. But you can have an option clause, and the option clause just basically says that yes, you own the copyright, but if at a date later in time, if I want to purchase, pay you whatever amount of money that the illustrator determines, right? And purchase the copyright outright, then I can do so. So it's that little caveat so it's not forever. It's not a license that lasts forever. You have that option later on if you want to own the copyright yourself.
Perfect. Wow, that's a lot. So now let's do a little deeper dive. Go to the next level. So we've got contracts, we've got our NDA, we've got the book ready to go, and now we're going into the trademark world. Tell us about why we need to trademark and what we need to trademark.
So a lot of authors don't think that trademark applies to them, but it can, right? Because you as someone, as a marketing professional, you're all about building brands, right? And just to differentiate, because some people might not know the difference between trademark and copyright. Remember, copyright is all about protection of an original work that's affixed to an actual medium, but trademark is all about brands. It's about brand distinction and brand protection. And what is a brand? A brand is just it's a phrase, logo, short hashtag, whatever, that's used in connection with a good or a service. So if you're offering a service or you have products and it's connected to a brand, a name, then that's something that can be trademarked. For authors, you have a few options. So if you're using your book as a platform to say, like, you're a coach, a life coach, or you're in finance or whatever, and you're using your book as a platform for speaking engagements or so forth, you're building a brand. And so you can use your trademark, you can use your book title, if you will, if that's the title of the services that you offer, or for your speaking presentation, or any of the merchandise that you sell. If it's the title, then you can trademark it for any of those products and services that you're offering. If you're using your business as the brand of your books, take case in point, Leap Forward Publishing is the brand of my books. It's printed on the back of each one of my books. That's the brand for the books that I sell. So it's trademarked. Leap Forward Publishing is trademarked for the class of goods and services that pertains to books and publishing. But also, if you have a book title, you can't trademark a single book title, but you can trademark a series book title. Think Harry Potter.
Why? But why can't you just trademark one? Why?
Well, because you just can't.
I mean,
because you just can't. You can't copyright a book title, and you can't trademark one single book title, because it doesn't operate as a brand. A brand is something that's ongoing, right? That has multiple products and services for. It's just one book.
Sure.
So it's not a brand. It's just one book.
Okay.
So no,
it's just one book. Okay.
So
I'm just like, people are gonna ask. So.
I know, but that's the reason why you could have many books that have the exact same title. Many books, because you can't protect the title. But if you have a series of books, then that's a whole different story. So you have, like, Harry Potter, Chicken Soup for the Soul. Those are for the For Dummies books.
Yes.
All trademarked titles. So another person can't come along and say Harry Potter and the blah, 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 because it's Harry Potter and the is trademarked.
So is it every time, but it's Harry Potter and the?
It's whatever the main crux of the title is for dummies, because all the books start with
for dummies, or
and it has whatever, or sorry, it doesn't start with that. It
ends with that.
Blank, blank, blank for dummies.
For dummies.
Yeah. So it's that main phrase that is on every single one of the books that makes it recognizable, because trademark is people think that it's all about protecting the business, but really it's about protecting the consumer. Because as a consumer, if I come to recognize a particular brand, like let's say I want to buy a BMW and I see the BMW symbol, that comes with a certain reputation. I know that I'm getting quality. I know that I'm getting luxury. I'm expecting something when it comes with that symbol. If I buy a
Back to
Pinto,
Canal Street, right?
right,
That's
if I buy like a Pinto or some, I don't even know if they make Pintos anymore, but some crappy car. If I buy some crappy car that has that on outward
a
appearance,
BMW
like a
emblem
Pinto,
on
yeah,
the hood.
right, that's going to harm the reputation of that company because here I am thinking that's a BMW and it's crap. So so it's to protect the consumer in the marketplace so that I can effectively distinguish one brand from another, and for the for the business owner, you or the brand owner, you're building up a reputation in that brand so that
That's
consumers
brand trust. That is the
brand.
trust.
Right,
Yes.
exactly. So with the books and the series, I know that if I see this particular series, I know who's writing it, I know the reviews, I know how great the series is, and I want to buy the next one.
Yes. Yes. I love it.
Yeah.
I love it. All right. And so we're at the bottom of the hour. We're going to keep going because I want to hear more about the read alouds.
Oh wait, we forgot
And
one more. We forgot the one other thing that self-publishers can do, and that you touched on it a little earlier with licensing a character.
characters. Yes.
You can license your character. So if you have a character in your book that's like the main character, what have you, but again, it's got to be used in connection with a good or a service. So with a character, it would be a product, right? So it may be plush toys or stickers or I don't know, t-shirts or whatever it is that you're using it for. You can license that character for those products and services. That's what you can think, like, SpongeBob or
Yeah.
and
Mickey Mouse is one of the most prolific. Yeah,
and if you want to think bigger, if you're like a self-published author and you have a pretty good series and you're thinking on a bigger level, like if Netflix picks this up or something like that, then they're going to want you to have a trademark to protect them.
Right. That's great. That's a very good point. Yes. And everybody wants their stuff on Netflix now. We're going to adapt all our stories for streaming.
Yep, exactly.
All right. So that's great. And we're going to recap all of these things. But your last area that you want to focus on is read aloud. So yeah, let's talk about the audiobooks because
That's so controversial, right? It's so controversial. It's always a source of debate because okay, so I've always been like kind of against read alouds in its entirety. In the book, it's in its entirety. But I mean, but then I kind of feel like
So when you're talking about read alouds, what do you mean? Because when people think about audiobooks, they're thinking about the author reads the book, they record it, and you're done, and then you share that out because that's another product, right? But when you're talking about read alouds, what are you talking about?
But that's for profit, right? If I create an audiobook of my book, I'm selling that. Unless I am intentionally giving it away, but I'm selling that. But when I'm talking about read alouds, I'm talking about you actually reading a book, and I'm not talking about like in schools and stuff like that. I'm talking about reading it on a open forum or open medium
in public.
In public, when you do that, you're essentially you can, and when you air it in its entirety, you can create an audiobook, whether intentionally or not, but you're creating an audiobook that could possibly compete with your book, with the actual sales of your physical or digital book. Because, a lot of people, they do these read alouds on, let's say, YouTube. You have some people who maybe they don't want to buy the book, or maybe they can't afford it, honestly, but maybe they don't want to buy the book and they go to YouTube and someone's reading it. Well, why do I have to buy the book if someone's reading it? And I can just have my child watch it, right? But it's kind of competing with your book. Now it's okay.
That's like copyright infringement, or isn't that? Yeah,
it is though. It is. But I mean, it's okay if the author gave their permission. I gave my permission for Ryan Reynolds to read my book and have the visuals on his show.
Right.
That's, I gave permission for that. But if someone has a show and they're doing book reviews or whatever, and they're reading it in its entirely, and they did not get the author or the publisher's permission, then it's not, no. I mean, you have exceptions to copyright, which are like fair use. teachers in the classroom using your book for, in teaching, they can do that. That's fair use. If they're doing it like on a virtual classroom or whatever, that's fair use. But if you're doing it for profit, no, no. You should be getting the permission of the author. So generally, when I'm asked, I will say I don't want it recorded, unless you're Ryan Reynolds. No,
Right.
no. I want it. I want to record. I don't want to record it, or you can record it, but you can only use snippets of it. And that's what most publishers will do. They will allow you to give, and I know during the pandemic, they were a little bit more lenient on it and allowing more people to do it, especially teachers. But yeah, that's it. Yeah, because a lot of people don't understand. A lot of people who have YouTube channels and where they do read alouds, they don't understand that they are essentially creating something. Now, if they're doing it for like one of the big publishers, maybe they might not mind as much. But if you're talking about a self-published author who is, once every sale counts, and you right, every sale counts, how minuscule it is, and you're now creating this audiobook that anyone can access, and maybe they might not want to buy it because
they already heard it. They're like,
they already
okay,
heard it. They already have the images. They could easily just play it on YouTube
over again,
over and over again. Then that's going into somebody's pocket, and you might not want to do that.
That makes a lot of sense. There are just so many things out here. Okay, and now we're going to talk a little bit beyond all of this. Let's go into the biggest issue of the day, which is AI. So how is that affecting? There's this big lawsuit with the New York Times taking the content from ChatGPT, taking content from the New York Times and using it in its algorithm. So what's your take on AI and the relevance of that right now with legal protection and publishing?
Well, what I focus on, and I have an article on my blog about this as well, is a lot of people I will see will come and ask me about AI as it pertains to illustrations for children's books. And no, I mean, it's
what do you mean no?
I mean, it's attractive. I know. It's attractive. It's attractive to do because all you have to do is kind of like, I did a presentation recently about diversity in children's literature, and I wanted as representation as a mirror and a window, right? And I wanted a room, a visual of a room with a window and a mirror. And I could not find something on the internet at all. So I put in ChatGPT, I need a visual of a room with a mirror.
Right.
And it came up with a great visual that I used in my presentation. That was awesome.
Wow.
I get it. You can kind of like ask it what to do, and then, and it comes up with these visuals, but you can tell that they're AI created, and they may not necessarily have that human touch of emotion, and there's always something that's missing from it. And then the copyright office says it's not gonna if it's not substantially created by a human, they're not going to copyright it. So you can go and have AI create all your images for your illustrations, all the illustrations for your book, and then at the end of the day, you can't copyright that.
Right.
So what's the point?
So what's the point?
Ask you in the copyright registration, they ask you if this, as far as text is concerned, was the text created using AI? And then if you say yes, then there's a whole other list of questions that they ask because they want to know, well, how much? Because I believe, I may be wrong. No, I believe it is that it has to be like 99% of it has to be created by humans. Maybe you just got the idea from AI, but it has to be your work.
That's it. So but that's really something that's changing a lot. And even, with, it really kind of raises the question though. It's like, what is your intention? Do you want something that is your original idea to come into the world, or you're just playing around with, technology? So really having the intention about what you're trying to do is something that should be kind of the way to check and stop yourself from actually basically
Yeah.
putting something out there
Yeah.
that can't be protected, that's taking somebody else's idea.
Mhm. Mhm.
Um, so that's really important. I
Yeah.
love that.
Yeah.
So
I
absolutely.
mean, I think ChatGPT has its place. A lot of
Yeah.
entrepreneurs use it. I think you and I have both used it.
Yeah.
Like if sometimes it can help you if you're stuck with an idea of something. It can give you suggestions.
Yes.
Uh, it's great for writing letters, for business letters and
Right.
emails and stuff like. But for your creative work, actual creative work, it doesn't sound like you. It's not your voice. We all have a unique voice, a unique way of wording things, and it doesn't sound like you. If you read AI stuff enough, you get to pick up on the
Yes.
nuance of AI to know that, hey, that's AI.
Right. That's a robot. That's not a real
That's not
person.
a real person. That's AI.
Exactly.
Yeah.
Yes. Yeah. So we're going to be wrapping up in a couple of minutes. So let's recap and tell us what you want your main takeaway to be for folks who are interested in making sure that their work is protected and in when they're publishing. What's your main takeaway?
Copyright. Copyright your work. You write it, you write a manuscript, copyright it. You can copyright it before it gets edited if you want. If through the editing process there isn't a substantial, like a huge change, then it's okay. But I usually copyright before I send it to editing, and then then file it when it's done. Why not? Before it's published.
And yeah. And one of the, I want to take I want people to take away also that this is another aspect. This show is called About My Book Business. You are in business, so you treat this like it's your business and you handle it in a way that is in line with that. So having those contracts in place, making sure that you have the right protections is important. And ultimately, think about if you're growing a business, you want it to be profitable, and having these legal agreements in place is the way to do that as well, to make sure that what is owed to you comes to you
Mhm.
and that nobody can infringe or and take and make money off of your ideas. And the other thing is, yes, the creative part with AI. Being a creator is something that only humans can do. So it's important to remember that as you think about what it is, the tools that you use and
Right.
how you use the tools and the technology that you have available to you.
Right. I totally agree. Totally agree. But yes, copyright, protect your work, protect your work. That's the number one. That's the whole premise behind the legal aspect of publishing. Protect your work.
Yeah. And that's why you wanted to come on and tell people about it because boy, oh boy, these people out here are in these streets doing some stuff.
When I tell people that it's $65 to file a copyright, they go, "What? Huh?
Right. Exactly.
Huh?
And you can put that in your budget, right? Like that's
Huh?"
part of
Right.
your
I mean,
plan.
and you know
Like,
what? And I'll say this. I don't usually. It has to be a person who just doesn't want to do it for themselves. That as an attorney, I'll charge them to. If you want me to do it, you got to pay to do it. But
right.
I do offer like tutorials. Like we can get on a call. You go on my website, see how much I charge. It's not much. And I do like a walkthrough. I walk you through the process because it's not hard.
But sometimes people will need more help. So how are they going to connect with you and get that help?
Oh, okay. So you can go to actually, I'm the owner of Mortimer. I didn't say this in the beginning, right? That I've been an attorney for 18 years and I own more. In addition to Leap Forward Publishing, we
You
probably should have said
did.
it from the beginning. Like, well, she owns a, why should we listen to her? Okay. Yeah.
Right.
So in addition to Leap Forward Publishing, I am an attorney, an intellectual property attorney, mostly in trademarks and copyright. And I own Mortimer Legal. I have a trademark phrase, trademark your assets. And you can go to trademarkyourassets.com. And if you have any questions, you can click the link to contact me, or you could schedule like a discovery call or what have you. But if you wanted to get a little bit more in depth with some of the things that I talked about today, you can go to deborahcmortimer.com and click my blog. And I have copyrights, trademarks, and I have blogs that talk about a lot of these things that I talked about today.
Awesome. I'm putting that in there so people will know that they can get your trademarkyourassets.com.
Yes. Yes.
There you go.
Yeah.
Got you. Got you. Wonderful. So thanks, Deborah. As always, it's great I love getting into these deep conversations about
Mhm.
I should have been a lawyer because I just love learning about all of the things. And, even in my experience in publishing, I've had the opportunity to work with lawyers. When I was in journalism, it was very interesting. Like an attorney was an integral part of our team every week for fact checking and protecting the brand when I was working at Time. And then, as well as when I was working in licensing, having those legal professionals always guiding us with that process. It's critical to have that expertise. And people may have a notion about how expensive it is to have an attorney, but believe you me, it costs more if you don't have one.
You know that's
My
right.
One of my favorite phrases, this is why I should trademark this. Pay now or pay later. And when you pay later, you pay greater.
Ooh.
All
Why
right.
why you put that out there before you trade? Why you put that out there before you trademark
Well,
it? Why you do that? Why you do that? But you're absolutely right. And I tell people that. I was like, oh, okay, oh, we don't want to trademark? Okay, no problem. Or, or you want to go forward with a trademark knowing that there's a brand out there that could come after you? No problem. Because you know what? I don't do litigation anymore. Those trademark litigators,
Ooh,
maybe I should, because they make a lot of money, and you never know how long it can go. Litigation can go on for
yeah,
years, and you're paying his attorney for years. So why not? Prevent is better than cure. Why
that's
not
right.
do whatever you can do from the beginning so that you can prevent that?
Right. That's right. I love it. Well, thanks so much, Deborah. We're gonna close up and
Yes.
we've got trademarkyourassets.com. Everybody reach out to Deborah because she knows what she's talking about. She just shared a little bit. And boy, we got a lot in this short period of time. So she's a great resource for you. And she knows the law and she knows publishing. And so if you are someone who's self-publishing or traditionally publishing, right? Because there are still issues that you need to address to protect yourself as an author. Then reach out to Deborah
Mhm.
and make your business, your book business, successful as it can be.
Yeah.
So we thanks, Deborah. We're gonna see you all next week. We have another guest, and you all will be hearing about that person soon. But in the meantime, share this with other folks when you get a chance, and watch it again. And you should be taking notes when you watch this. So we will see you all again next week. And Deborah,
Yeah.
thanks so much. I love doing this with you.
This is so much
And
fun because
yes, it was.
we have these conversations on a regular basis anyway, right?
Anyway,
Why not
anyway.
share?
Exactly.
Right.
Thanks so much.
All
All
right.
right. Bye, everybody. Have a
Bye.
great night.
See you
Yes.
next week.